What every Social Security disability applicant with cerebral atrophy needs to know about steps 4 and 5 of the 5-step sequential evaluation. If you don't meet a listing at step 3, the Social Security Administration will determine your entitlement to benefits based on the medical and vocational criteria at steps 4 and 5. At step 4, you have to show that you can't go back to the lightest job you held in the 15 years before you became disabled. And at step 5, you have to show there isn't any other work that you can do in the mythical national economy based on your age, your education, your transferable skills, and your residual functional capacity. Unfortunately, the Social Security Administration is trying to figure out what your residual functional capacity is, and that is what you can do despite your cerebral atrophy. Unfortunately, the Social Security Administration can rarely figure that out based on a person's medical records, and as a result, they will refer your file to a medical consultant, and that medical consultant will pore over your medical records. Now, what they want to know, the Social Security Administration wants to know, is whether you can do sedentary, light, medium, or heavy work. And I assure you that if a Social Security medical consultant has to look at your medical records, they'll opine that you could do some level of work that would result in a claims denial. The reality is that you should have a residual functional capacity form completed by your physicians. Now, there isn't one per se for cerebral atrophy, but because cerebral atrophy is caused by underlying medical conditions, you should have one filled out that relates to that medical condition. What's important about these forms is that your doctor will be asked questions about how your language disorder impacts your functionality, how your progressive impairment of memory and intellectual function impacts your functionality, how problems with memory alone impacts your functionality, what problems you have with orientation and visual spatial perception, how does that impact your functional capacity? Do you have problems with higher executive functions like planning, organizing, sequencing, and what are those problems? What is your ability to perform a routine, simple task over and over? This isn't an exhaustive list of the types of questions that should be addressed by your physician, but I'm sure that you can see having an explanation of what you can do cognitively is the key to winning your case. I also think that neurocognitive testing is crucial. Many cases are lost because the applicant didn't have that residual functional capacity form filled out or didn't have the neurocognitive testing. Well, why is this important? Because from a vocational standpoint, as I've said, they're trying to figure out if you can go back to the lightest job you did in the 15 years before you became disabled, which really means the simplest job you held, and whether there's other work you could do in the mythical national economy. The key here is if you have to have a hearing, the judge will determine your residual functional capabilities, and they will then turn to a vocational evaluator who will be at trial. They will be asking that vocational evaluator hypotheticals about you. So the hypothetical may go, I want you to assume that this person could sit 6 out of 8 hours, stand 6 out of 8 hours, lift up to 10 pounds. Can this person go back to the simplest job they held in the 15 years before they became disabled? Now, isn't that a crazy hypothetical? Because that hypothetical offered no information about the cognitive problems that you have. If the VE says yes, you lose. And if the judge doesn't add to that hypothetical the relative problems that you're having, you're going to lose. If the judge doesn't go on and ask if there's any other work in the national economy you could do and view that hypothetical, you will lose. And if the judge accepts that vocational evaluator's testimony that there's other work that you can do, you will lose. I hope that you see that it's crucial that you have someone represent you from the time you file your initial Social Security disability application through the hearing process. The application is confusing, and I think it's designed so that you make mistakes that will result in a delay or denial of your benefits. In fact, did you know that over 2/3 of cases are denied at the initial application stage? And I think that's because the applicant doesn't understand how to give a winning history of their work duties and doesn't have a residual functional capacity form. If your claim has been denied, you'll have 60 days in which to file a request for reconsideration. Many people make the same mistakes that they made the first time. And if you're denied, again, you'll have 60 days in which to file for a hearing. A hearing is a trial. That means you're going to be in front of a judge. You have no clue about the 5-step sequential evaluation, no idea what's in your medical records, no idea about how to get a winning residual functional capacity form, no idea of how to present your case to the judge, and certainly no idea how to cross-examine a vocational evaluator. Do you know that the odds of getting your benefits are greater when you're represented by an experienced Social Security disability attorney like myself? Why would you want to risk losing your Social Security disability money benefits and medical benefits? Doesn't make any sense to me. I would suggest that you give me a call at 727-894-3188 for a complimentary consultation. Call me today, 727-894-3188. Make the call. Cavey Law.